Welcome everyone. Today I am going to attempt to save you from being in a situation where you get your assets obliterated and avoid some really bad information that could be out there related to protecting your assets, the liability, people suing you, divorcing you, child support, having other different claims come after you. Because let's be honest, we live in a world where there is increasing amounts of litigation. There are some people who feel like their retirement plan is to sue somebody rather than to actually build productivity in the world. And therefore, it's super important for us to be able to go and to preserve what it is that we produce. However, unfortunately, there's a lot of misinformation out there. And I'm going to share with you today the myths and the realities of what you can expect. We will call this the cold realities of asset protection because unfortunately it is not as good as people would like you to believe in what they share in all sorts of online articles, etc. It just does not reflect legal reality. So we're going to talk about the real tricks that you can use. I'll talk about those at the end, and we're going to talk about all the ways that you can get yourself screwed up so you avoid those. Let's talk about that right now. Now, if it's your first time here, welcome. Please hit the subscribe button, hit the all notification bell. Thank you for being with us. I am Michael. I run my team of international experts related to the offshore space. We help people to figure out how to optimize their global tax, protect their assets, achieve more freedom, plan Bs, etc. There's tax planning, there's fund company formation, there's bank account setup, there is residencies, there is citizenships, and many other tools that we can help you out with. So if you're interested in any of that, please reach out to us. You can book a call with me, calendly.com/Michael-Rosmer. There's a link in the description below, or you can send a message through offshorecitizen.net. Okay, so my original mentor, the person who originally taught me about things related to offshore, I've had a number of them over the years and have benefited from all the different team and people we collaborate with around the world, etc. But the original person was a very brilliant international attorney, and he had helped to draft a lot of different legislation, including the Belize Trust Act and some other things. And he would often kind of share the difference between what may sound good on paper and what is good in practice. And there's another attorney you can check out named Jay Adkisson. He has published a bunch of different things in Forbes where he'll go through and he'll review actual court cases to show you the difference, because you get some narratives which are essentially, hey, just set something up in a Cook Islands Trust or a Nevis Trust or a Panama Foundation or Liechtenstein Foundation or Seychelles or whatever, and your assets are going to be magically safe. And this is unfortunately not the case. So I've done some content in the past on asset protection. You can go back and check it out, and I will put some more out that is kind of more comprehensive over the next little while. But for today, let's just recognize that the idea of asset protection has essentially two parts. The first part, and if you want to kind of get a summary of this overall, you can read a book called Lawyers Are Liars. It's a great little introduction, mostly from a US perspective, but still a nice little introduction to the subject, is about reducing the chances that somebody attacks us and reducing the losses in the event that we get attacked. Okay, and when we say attacked, we really mean sued, that somebody brings some sort of a litigation claim against us, some sort of a legal attack on us. Okay, this could come for totally benign reasons. You know, maybe you own a property and somebody is walking up the front path and maybe it's icy and they slip and they hurt themselves. It could be for some really malicious reason because somebody wants to get at you for some reason. It could be from some nonsense like an employee who has been in a situation that they think they're entitled to more and therefore they could go and sue you, etc. It could be somebody like a spouse coming after you for divorce. It could be, you know, injury claims are a big one, etc., etc. Like there's a gazillion different scenarios under which this could happen, including governments going after you. Okay. And so what is it that we want to do in these particular situations? Well, what we want to do is we want to separate out our assets so that they're somehow protected. We're essentially building a castle. We have walls and moats and defenses to try and protect them. And what this will hopefully do is reduce the likelihood that somebody's going to attack because they think, oh, if I do this, it's going to be difficult to get the things in there. And then in the event they still proceed and there's still some chance, they will be willing to settle for a lot less. Okay, that's basically the objective that you have here when you're talking about asset protection. And there's common vehicles that we use. So in the US, there's things called exemptions, and there's exemptions in a lot of places. So we look at bankruptcy law for this very frequently. And these are things that they are not allowed to take from you. So for example, a really common one is something called the homestead exemption. The homestead exemption is all about your house, and it varies state to state. In some states, there's really no limit on the value of your homestead exemption that you can get. In other places, the value is pretty low. In a lot of countries, you have rules whereby if you get sued, they aren't allowed to take things that are like necessary for your life. So maybe if you have a vehicle that's necessary, etc. It's really frequent that, for example, your retirement savings will not be allowed to be attacked if they're in some sort of a registered, like a pension fund, right? So the most classic example of this is the O.J. Simpson case, where he was in a situation where he was sued civilly, even though he had been acquitted in the criminal case, and he lost. But they weren't able to get a lot of the stuff because he lived in Florida, and the two main assets he had were his home and his pension, and so neither of those were accessible. So it was like $300,000 a year or something in the pension, and the home was worth quite a lot. So I'll do maybe a special on how O.J. Simpson's asset protection worked in the future. Let me know if you want that in the comments below. But the point is that he had some sort of defense that would limit the amount of damage that was against him. So the cheapest, easiest path to take generally, if you're in a situation where you can get it, is to be able to take advantage of these exemptions, right? These exemptions don't exist in all parts of the world, but they exist in some parts of the world. There are other strategies that are used which are designed to try and reduce the visibility of what's going on. So for example, there's a common strategy called equity stripping. What is equity stripping? It's essentially where you place a loan registered against an asset, and so you show that the asset essentially has no value. So a house is the best example, right? You buy a house for $1 million, you say, okay, great, I got a mortgage for $900,000 on it, and that's a fake mortgage, right? It's not a real mortgage, and hence there's no equity, and therefore they look at it and they say, there's only $100,000 there, I'm gonna have to go through all this trouble, it's not gonna be worth it. The mortgage holder is going to have first claim on the asset anyway, et cetera, right? That's the idea. Now in practice, this is the kind of cold hard facts, is that if you're creating a false mortgage, there's not actually a real mortgage there, a court is basically going to discard that, and it's not actually going to be available to you as some special means of protection. The next thing that we would commonly see is we would see something like the corporate veil. Now, the corporate veil is perfectly legitimate and good in perfectly legitimate and good situations where you have proper corporate governance. So for example, there has never been a US public company which has had the corporate veil pierced, which is pretty impressive, right? There's a lot of US public companies. Why is that? Well, first of all, because there's a lot of shareholders, and so saying that a given shareholder is responsible for what went on is pretty difficult. And at the same time, you're in a situation where there's generally pretty good corporate governance because that's part of being a public company. So this is not the situation that most small business owners are in, where they're maybe the only owner. And so corporate veil, it matters, but it can definitely be pierced in most places. Now there's some countries, for example in Panama, there's no concept of piercing the corporate veil. This doesn't necessarily matter, as we're going to get to in a moment, but in certain circumstances it could matter. And so this is essentially where they say, well, you're liable anyway, or there's some sort of a sham, there's an alter ego here taking place, there's different kind of language around how this works, but they essentially disregard the corporate veil and go directly to the owner or the director or somebody else and bring the liability there. And if you're the only person in that company, it's pretty likely that they can do that. Granted, there's some more legal process involved, so yes, it increases the cost for them to do so, but this in itself is probably not going to have much mileage. Now, if there's a bunch of owners and the owners are not necessarily involved directly, that's a whole other conversation. So you can kind of reproduce functionally what is present in a public company, and then you can get some serious value out of the corporate veil. However, that's only for the attacks that come from within. So we talk about inside and outside attacks when we're talking about asset protection. From within the corporate veil, meaning the company is the one that has the liability, and so the liability is limited to that legal entity and doesn't spill beyond. You'll notice that really big companies have lots and lots of legal entities, and yet it doesn't really help them to isolate their risk very well if, for example, you have something like the Samsung and Apple case, right? Apple suing Samsung for violation of their trademarks. It's not like they were able to say, oh, you know what, we're going to put most of our assets in some entity here, so you can only go after this other entity and the rest is off bounds. It doesn't really work that way. So very important to understand. That's kind of the cold truth, that big companies with all the resources, with international structures, et cetera, are not able to protect that in a situation where you can clearly say, well, the main central body is responsible for this decision, and it's really all under the same thing. So keep that in mind. Next, what do we have? We have the ability to put assets into something like an insurance vehicle. Now here we're starting to get more serious, right? I mentioned you have these exemptions that are in place. So exemptions generally are a perfectly legitimate vehicle. They just tend to have a pretty low limit and limit from certain things, right? So it doesn't protect you from everything. So a good example of this would be Paul Bilzerian, Dan Bilzerian's father. So you can go and check out this really interesting video on YouTube where they talk about his protection strategy and all the different tricks that he used. Now, they went after his assets. He had a home in Florida. Florida has an unlimited homestead exemption, although that is on value. It's not necessarily on size. So there are some nuances about how this plays out. And he ended up losing the home through this. So in spite of the fact that there was a homestead exemption, in spite of all this other stuff that went on, it didn't necessarily protect him. So that's, again, you have to be aware of what are you dealing with, what are the circumstances, et cetera. So, barring some extreme things, yes, it can help, but it depends who you're protecting from, it depends on what the asset is, it depends on other circumstances around what's going on, okay? Very, very important. However, insurance is a pretty good one where, generally speaking, insurance policies do provide you with some protection. So the insurance will pay out to protect you. That's the first thing. If you're actually buying, say, liability protection, great. The second thing that can happen is you can be in a situation where you can put money into, say, life insurance. And so this can allow you to scale up the value of assets that are protected. Generally speaking, life insurance is creditor protected. Generally speaking, it bypasses bankruptcy. And of course, it has some other benefits, death benefit, et cetera, along with that. So that can be something good, although there are typically limits, and whether it's cost effective for you or not, depending on your goals, is hard to say, right? So that's the next part. This brings us to kind of really sophisticated strategies, which would be trusts and foundations, okay? So when we're talking about trusts and foundations, this is where I think we start to get the most misinformation coming in. I'll hear all kinds of people who hear this story that, oh yeah, you just put your assets into a Cook Islands trust or into a Nevis trust or something like that, and they can't come after it because you don't own it, the trust owns it, and therefore there's nothing at risk. This is true in certain narrow situations, but if somebody's telling you this broadly, they probably don't know what they're talking about. So let me give you an anecdote from this very skilled attorney who was kind of the first person who ever trained me on the subject. He gave a narrative. He said, hey, imagine that somebody in Canada is getting divorced and they have a piece of property which is located in Calgary, which is a city in a city in Alberta in Canada, okay? Let's just say they put it into a trust. Let's say they're even smart enough to put it into a Cook Islands trust, or sorry, not a Cook Islands trust, a Turks and Caicos trust, okay? And you might ask, well, why Turks and Caicos, right? So very quickly, the reason for this is because Turks and Caicos has a fairly unique distinction amongst many of the asset protection jurisdictions, that it is part of the Hague Convention on the Recognition of Trust and Their Applicability, which is a 1985 treaty that was signed between countries that allows foreign countries to domestic countries to recognize foreign trust law. Okay, so very, very interesting rules, very, very interesting. And so this offers a degree of protection that actually you wouldn't get in something like Cook Islands or Nevis or Belize or Grenada, because these are not countries that are signatories to the Hague Convention. Interestingly, Turks and Caicos is not a signatory either directly, but what happened was they were so corrupt and messed up, the UK went and kind of retook them over, and so the UK is a signatory and they were brought in under UK. So it's a really kind of unique thing that went on there. And so that's very interesting depending on where you're looking. It's not necessarily everywhere. It could be, in some places it's important, in some places it's not important. It depends on whether you have countries that are signatories, depends on where the assets are, et cetera. So I'm not saying by any means to go and do this. Always, asset protection is super nuanced. You should reach out and we should go through the specifics for you. What are the assets? What are the objectives? What are the timelines, et cetera, et cetera. But this being said, for the purpose of this example, which he was giving, it turns out to be a really useful tool, right? So you say, okay, great, I've got this property, which I don't own it, is owned by a Turks and Caicos trust. Fantastic. So what would happen most likely in practice if you go to court? And that is the real key, right? So you go to court for this divorce, okay? Wonderful. You're going to be going before a Canadian judge. Let's note this. And so the judge sits down and looks and says, oh yeah, I see that we have this property in Calgary, which is part of the assets of the couple. You say, well, actually, no, Your Honor, that's not accurate. That property is not owned by us. It's held by a Turks and Caicos trust. And says, okay, what does that mean? He says, well, Turks and Caicos is a signatory to the Hague Convention on the Recognition of Trust and their applicability. He says, okay, great. What does that mean? He says, well, it means that you need to try this according to Turks and Caicos law. And maybe the judge, maybe you get a very progressive judge who's thinking, he says, okay, well, you know, I'm hip, I'm progressive, I'm all for this. You know, what does that mean? Says, well, that means that you have no authority here, Your Honor. And at that point in time, what is most likely to happen is that they're likely to say, okay, look, you're here, the property is here, the plaintiff is here, I'm here, we're going to try this according to Canadian law, and we'll deal with the rest later. And you might think, oh, great, you know, I had this wonderful structure. But in reality, the cold, hard reality of this, the cold, hard truth is they go through it. And there's case law going through examples of this, for example, in various parts of the US, where there's a famous one. There was a situation with an Alaskan trust, which has better rules. And there was, I think, something was in Washington and something was somewhere else. And basically, because Alaska had nothing to do with what was going on. The parties weren't there, the assets weren't there, et cetera. They just threw out Alaskan law and decided to go with, I think it was Washington law in this particular case. So all over, they have this question of choice of law. And choice of law is a really, really important thing. So you might think, oh, great, you know, why wouldn't I go and use Cook Islands? This is like, people will call me up and they'll say this. The reality is, unfortunately, depending on the location of the assets, depending on the location of the plaintiffs, as well as yourself and what all happened, they may just throw out Cook Islands law. Now, it's useful if the assets are in Cook Islands and if the trustee is in Cook Islands. Okay, then it's useful. So people will say, oh, you know, I'm going to be protected from divorce in, you know, a trust or a foundation. Often not. Another part about this is that there's something called there's a variety of different names for it depending on where you are in the world. But there's something called the Uniform Fraudulent Transfers Act. And this is a US name, there's Statute of Elizabeth, there's et cetera. But the bottom line is that if you try and do a transfer for the purpose of depriving creditors, okay, then they will reverse those transactions and undo everything that you did. So in other words, if you come out and you say, all right, I'm going to set up a trust because I'm getting sued, so I want to protect the assets. No, 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 you don't get to do that. They have laws to prevent you from doing that. So you kind of have to understand that courts don't operate based on some magical set of laws. They operate based on substance rather than form, okay, when there's a conflict. And as a result, if you went and transferred some assets, literally a good example of this is in the Bernie Madoff case, a lot of people ended up having money clawed back from them because it was considered to be fraudulently transferred. And I mean, they weren't even trying to protect anything, right? But the point was, it wasn't their money to give, and so it was a fraudulent transfer. This is a big concern in the FTX case. In the FTX case, there's a concern that they've been disseminating all this money fraudulently because it wasn't their money, it was customer money, and that therefore a lot of this could get clawed back. Same sort of, and literally like, you know, can go after grandmothers. There's a, if you want to go and watch the Netflix documentary on Bernie Madoff, very interesting to see what all took place there. Anyway, the point is, very, very important that you cannot simply arbitrarily decide, I'm going to go protect these things in this way. Now, if you know, go and just give away the money, you lose it in, I don't know, some gambling spree or something, then sure, maybe they won't be physically able to retrieve it, right? It's possible to not physically be able to retrieve it, but you won't be able to retrieve it either. So, you know, it's like you could take it all as cash and burn the cash to fire, and, you know, nobody would get it, but you don't get it, right? So part of the point when you're doing asset protection is not just protecting it, but making it functional for you in the process. And this is an entirely different game, totally different, okay? Very, very important to understand this. Another thing to understand is that there are what are called exception creditors, okay? So frequently, a spouse is an exception creditor. Really, this is maybe a pro to Nevada. If you look at Nevada trust law, in Nevada, it's like one of the rare cases where a spouse is what's called a no exception creditor, meaning that even if very often what will happen is they'll say, okay, we're protecting from people except the spouse, right? But in Nevada, they say, no, even the spouse we're protecting against. So very, very important to understand that this is a big deal as well, okay? Foundations, it's the same basic principles. So what is the key that you need to do when you're putting all of this together? Well, first of all, you want to make sure that if you're utilizing some sort of an asset protection structure, okay, and you're saying, okay, I'm relying on the strength of the legal structure here, then the assets that I'm protecting need to be in the same place as where that structure is located. And this kind of makes places like Cook Islands and Nevis not as useful, because what's the quality of banking in Cook Islands and Nevis? Not that great, right? What are the sophistication of things that I might want to use to protect me? Not that great, unfortunately. Now, this might make some place like South Dakota more attractive because maybe there's more that you would want there. Maybe this makes some place like Liechtenstein more attractive for whatever reason. Depends on what the assets are. But the whole point is, it's not like you can just say, oh great, I'm going to set up in Cook Islands or Nevis or Bahamas or wherever else, because you may find that if your assets aren't there, who cares? Okay, so very, very important. That's the first thing. What you care about when you're thinking about asset protection is not just the legal shelter, but also the jurisdiction and the choice of law part. Okay, that's point number one. Point number two, when you're designing an asset protection structure, you shouldn't actually design for asset protection. You should actually design for wealth preservation. Okay, important distinction. Wealth preservation extends far beyond just asset protection. And what this means is that you want a mechanism by which you or those you care about can use that wealth. It's not just protected from creditors. As I said, it's not that difficult to deprive somebody else of assets. There are ways to kind of like get rid of assets and not have somebody else get them. But what's the real key is being able to deprive somebody else of getting them and being in a situation where they're still functional to you. I'll give you a final really important court case that took place. So a woman's husband had a fairly major tax debt, and she had a trust, or he had a trust of which she was a beneficiary in Isle of Man. Okay, Isle of Man actually has fairly strong trust laws. People don't talk that much about it, but it was updated quite a bit to be pretty competitive. A lot of people know about Cook Islands and Nevis and think of this as like the preeminent places. The reality is a lot of trust laws have changed over the years, and so I wouldn't really give them that definitive an edge. There are some really cool things in their laws, but a lot of places have copied most of the qualities that are good since then. So these assets were in this Isle of Man trust. Okay, cool. The government came to her and said, look, your husband has this tax debt. We want to collect, so therefore bring the money. And she said, oh, I can't. I don't have any control. That trust is under the control of the trustees. I can write to them and request it, but the best that I can do is that. And that was exactly what happened. And under the terms of the trust, there's an Antidares Clause in the trust. This is one of a common set of clauses that we would have when we design one of these. Trusts are super complicated, by the way. Normally when we do trusts for people, we're talking about like a 50-page document. So very nuanced, lots of planning goes on. It's probably about a 6-week process to go through setting it up. It is not simple. It's going to cost a significant amount of money. And if you're not doing that, you're probably setting yourself in a position to be disappointed. So anyway, I said, okay, great, we have this anti-duress, which means that the trustee in Isle of Man said, nope, the court is trying to get this money. It's not actually going to the beneficiary, so therefore we're denying it. All right, so the government said, it's called the impossibility defense. Okay, the impossibility defense is, I cannot comply with the court's request. It's impossible for me. And so, okay, great, perfectly fine. Government goes away, money is safe, right? Not exactly. What really happened is, over time, money was flowing from that trust to the beneficiary, this woman who had her husband's money left in the trust. And the government saw that. They said, well, hang on a second. If you can get money from the trust, then we're not going to allow this to happen. And they essentially act like a giant python or boa constrictor or anaconda, and they constrict you. They go and they say, look, you can't get it, fair. Or sorry, we can't get it fair, but you won't be able to get it either. and all the money that's coming, we're just going to garnish it. And essentially, they put you in a position where they sort of bleed you out. It creates this standoff where it's like, okay, what is the negotiation that you're willing to come to? Now, maybe that's better off than a situation where you didn't have this standoff. And the truth is, she could have left the country. This was in the U.S. She could have left the U.S. to go and live somewhere else, and then being able to be outside of U.S. court jurisdiction, and that would have been a bit of a different situation. But most people are not willing to do that. So very, very important to understand. You want to, yes, build up a strong legal defense, right? This involves sometimes trusts, sometimes foundations, sometimes we do some really effective stuff with limited partnerships that is very fancy and cool. Sometimes it's insurance, sometimes it's location of assets, sometimes there's lots of different parts that go into this. Legal contracts, etc. Okay, that's all important. You have to pay attention to where the assets are that you're trying to protect, who you're trying to protect them from, what the nature is of the types of threats that might be coming at you. And it is just unfortunately not as simple as what it is that a lot of people would like to tell you on the internet. So if you'd like to hear more about that, please check out some of our other videos on the subject of asset protection. Reach out to me, book a call, and I will look forward to seeing you on the next video.